on our website. There we go. Nicole's going to keep an eye on the waiting room and let anybody that is still wanting to come in. And we're going to be keeping an eye on the chat function as well for any questions that you might have. And I'll be sharing my screen as well with a little bit of information. So the meeting is recorded and we've got about 70 people online. And I thank you all for making time this morning on a lovely Friday morning, nice and crisp in Cape Town this morning to have a chat with us. Welcome officially to our June or our birthday month webinar. It is both TVDM's birthday, 1 year, as well as my personal birthday month. I won't tell you how old I am, definitely not 1 year, unfortunately, but it's been a very, very exciting and fantastic time that Nicole and I have embarked on the last year. Can't believe that it's been a year, although if you look at how grey hairs popping up, we can most certainly believe that it has been a full year. So we'd like to firstly start off with just thanking everybody so much that has supported us. Thank you. Happy 21st birthday from Serena. Thank you. Forever 21, that's it. We'd like to first just thank you all for supporting us over the last year, you know, as clients, as friends, as colleagues, as mentors. I am going to refrain from mentioning names because when I think about it, number one, I want to tear up and I blame it on pregnancy hormones. And number two, just because there's so many people. So yeah, just thank you so much from both of us from the bottom of our hearts for supporting us over the past year. And I hope that we continue to grow from strength to strength. And that's our main aim of building relationships and strengthening relationships continue throughout the industry. So thank you very much. So to celebrate today's birthday month webinar, we'll be giving away some of our time. So we'll be giving away 1 hour of consulting or training time via Zoom to a lucky participant and attendee. Nicole has done a bit of a randomizer at the beginning, so she'll announce that, and obviously, well, I'll announce that rather. And if that person is online, they'll be the lucky recipient of a 1 hour consulting or training session with us. Let's hope that they would appreciate that. So before we get started with what I believe is a very exciting topic, which is rules in a sectional title scheme, we have quite an exciting announcement. Some of you might know already because I can't keep my big mouth shut. For those of you that don't know, Lemise Finch, Lemise, your camera on, you can wave at everybody so they can see you. Lemise Finch has joined us on Monday as a consultant. Lemise is fortunate enough to not have had the boring start to her career of a law degree. She rather specialized in psychology, which I think is perfect for this industry. And she has been a managing agent for many years with quite a few leading managing agencies in Cape Town. So welcome, Lemise. I know that everybody is going to be very excited to get to know you over the coming months. I'm not going to put you on the spot and expect you to say anything unless you absolutely want to. But please go and visit our website afterwards to have a look at her profile. And we wish Lemise everything of the best with her adventure with us in the coming years. All right. So those of you who may or may not have joined us on the 13th of May, we had a guest speaker from the CSOS, Jolene Wasserman, attend a webinar where we discussed the CSOS Practice Directive that was issued. The Practice Directive dealt with rules in a sectional title scheme, management rules and conduct rules. The recording of that webinar is available on our website, along with Jolene's slides, a copy of the Practice Directive, and Jolene very kindly prepared a Q&A document of all the questions and answers that were in the chat function during that webinar on the 13th. So that is also being posted on our website. So what I would like to do today, and this is really based on a lot of interaction that I've had from a lot of you that are in attendance, and of course that's a very popular sectional title group on Facebook, where people have really quizzed the Practice Directive and what the CSOS intentions were behind a lot of those rules. I would really like today's session, like I said, to be interactive and engaging. So you're more than welcome to please post your question in the chat function or raise your hand or keep your questions to the end. Really, nothing is off limits. If the topic of rules is way too boring for you, I don't blame you. You're more than welcome to something else towards the end. Just a reminder that if there is some background noise, to please just mute yourself. Thank you. So what I'm going to be doing is sharing the practice directive. Just bear with me to make sure that I share the right screen.
Yes, I can see it.
Okay, fantastic. So the practice directive is about a 20-page document. The part that is of real interest to us today is the undesirable rules. What I am going to do, although I'm not sharing any slides this morning, I'm going to be addressing formal correspondence to Jolene at the Community Scheme Ombud Service. That formal correspondence will be made available to all of you as well. And I'm going to ensure that I open it up to any possible comments or queries from your side as well. So following the session today, if there is anything that you weren't able to raise during the session, then please do let me know afterwards by popping me an email or popping something into the chat function, because I'd like to use this opportunity to put across any comments or queries that you might have to the CSOS. And of course, once they respond, I'll make that response available as well. So firstly, and I must do a little bit of a sales pitch, otherwise my partner will most certainly complain and moan at me after today's session. Just a reminder that TVDM consultants do offer a set fee for review of your body corporate's management and conduct rules. We provide an amended set of rules, followed by consultation and final amendments. We can also assist you in consulting with your owners or attending a special general meeting or annual general meeting to deal with the amendments. And then, of course, dealing with the submission to the CSOS as well. So if you'd like more information on that, please do contact us. So firstly, the circular that was made available by the Community Scheme Ombud Service is known as a Practice Directive. And we know that in terms of the Community Scheme Ombud Service Act, the CSOS is able to make practice directives very similar to what the Deeds Registry makes registrar circulars or chief registrar circulars available. And this is basically to assist in the interpretation of the Community Scheme Ombud Service Act, as well as the Sectional Title Schemes Management Act. Something that is exceptionally important, and it is set out in this practice directive, is that the practice directive is not intended to amend, replace, override, or supersede the Community Schemes Ombud Service Act or the Sectional Title Schemes Management Act. So very, very important to remember that no practice directive can be in contravention of the Sectional Title Schemes Management Act, which includes the regulations, which is the management rules and the conduct rules. So the first hurdle that we've had to jump over with regards to rule amendments is that when a body corporate has approved management rules by unanimous resolution or conduct rules by special resolution, they've had to submit it to the Community Scheme Ombud Service within 10 days with a Form B, a copy of the amended rules in consolidated format. And please do post your question as to whether or not you know what a consolidated format is. I'd be interested to see the responses there, with the unanimous or special resolution. And then, of course, quite interestingly, the minutes of the annual general meeting and the special general meeting where the amended rules were approved. Now, it's obviously a lot of pressure on the trustees or the managing agent to make sure that those minutes are done within the 7-day period in order for the rules to be lodged within 10 days. But the Community Scheme Ombud Service requires that these minutes be signed. So this is the first question mark from my side, is that we know that minutes can only be signed off by the chairperson once the members have approved the annual general meeting or the special general meeting minutes at the next annual general meeting or special general meeting. So that's the first question I'm going to be raising with the Community Scheme Ombud Service, is why do these rules have to be signed? The practice directive speaks about the fact that it cannot be authenticated if it is not signed, but going against the sectional title, or rather requiring the minutes to be signed, would be going against the Sectional Title Schemes Management Act that requires approval first. So that's something to look at. I think it might have been Lemise, when she was still with Intersect, that gave us the first instruction after this practice directive to lodge rules, and we had to ask them to sign those minutes. And if memory serves me correctly, Lemise, we asked you to give us those minutes rather in draft form, like with a draft watermark through it. That's pretty much the best we could think of on our feet at that point in time to at least comply with this requirement of signed. and to be supported by the trustee resolution to say that it is being signed for the purpose of community scheme ombuds service submission, and that it in no way attempts to approve the rules prior to the members approving it. Now, having a look at the undesirable rules, we've known for a long time that there are a list of undesirable rules made available by the Community Scheme Ombuds Service, and this is what they will not allow when they review and approve our conduct rules and management rules once amended. The wording of the undesirable rules category of the Practice Directive, in my opinion, is a little bit stoppy, for lack of a better word, or a little bit unclear. And there's a lot of these that I would simply like some interpretation or clarification from the Community Scheme Ombuds Service. All right, so I've broken it up into about 15 categories, one of which our colleague Shirley Bailey is going to be taking us through, which is ritual slaughtering in community schemes. But the first one that I'll be looking at is fines and penalties. So this is one that we've known about for quite a while, in that a fine or a penalty cannot exceed or be more than a monthly levy of an owner of the unit concerned. So whenever we consult with trustees and managing agents, we say, what is the lowest levy in your scheme? Obviously, levies are different based on participation quota, the size of the units. So it's relatively simple to see, in this case, we can't charge more than 1,000 Rand. In this case, we can't charge more than 1,500 Rand. Of course, it's really actually quite unfair if one has to say, well, because you have a larger unit, we're now going to charge you a higher fine. And I don't think that is what it was intended by the Community Scheme Ombuds Service. So I would like some clarification in that regard. The other question that we have is, does this mean that the amount cannot exceed or be equal to a monthly levy once off, or in total raised for that particular owner? In other words, once we've raised 1,000 Rand fine and their levies is 1,000 Rand, does that mean we can't raise another 1,000 Rand that month? Or does that mean we can't raise another 1,000 Rand until the dispute has been resolved? So there's a little bit of clarification that is needed there. They also go on to say that trustees do not have the power to decide on the fines or penalties or to take action against an owner or occupier. Now, my question is, does this mean that the amount can't be in the rule, or does it mean that no summary fines are allowed, or does it mean that due process has to be followed? So what we do in our rules is we don't like a schedule of fines, because very often we find that an event might not, or a contravention rather, might not necessarily be covered in terms of that schedule of fines. So we prefer to say that, there's a first offense, a second offense, a third and further offenses. The amounts will range from X to Y. We like to ensure that irrespective of the size of your units, the same fine will apply on you, provided it is not equal to or more than a monthly levy of the lowest paying levy owner. And then, of course, we don't have any summary fines. We do provide for a due process. So I'll be sending our rule to the Community Scheme Ombuds Service to see whether or not that is sufficient. Our rules in this regard have been approved previously, but we haven't seen any rule approvals since the Practice Directive has come out. So it'll be interesting to get that information first and foremost. And of course, fines and penalties in a sectional title scheme is of utmost importance, because without that, it's quite a toothless exercise. There's no enforcement mechanism. The second issue that we're going to be looking at is the recovery of legal costs. So this is a pretty important one when it comes to sectional title scheme management as well. Where am I? I've gone right past it. There we go. Let's just leave it there for now. So the recovery of legal costs. The question is, can you amend a management rule to allow for the recovery of legal costs, or can you not? And again, the Practice Directive isn't that clear when it comes to the recovery of legal costs. There are two separate clauses in the prescribed management rule. One says that you have to have the owner's agreement. Good luck with that. And the other says that you have to have a text. Now, the second provision speaks about, as long as it is in the rules of the body corporate, those legal costs and other charges can be recovered. Another colleague in the industry, Willie Riss, of Stratafin, and I met with Jolene after the 13th of May to discuss this issue. And I don't know if Billy is with us this morning or Daniela is, but I still don't have clarification on that. So this is again something that I'd like to take up with the Community Scheme Ombuds Service. My concern with regards to the recovery of legal costs, or not having the ability to recover legal costs, that it's most certainly going to affect arrear levy collection first and foremost, and again enforcement of the rules when it comes to contraventions as well. The third issue that we're going to be looking at is owners notifying the body corporates of a change of bondholders. So according to the Practice Directive, an owner does not need to notify the body corporate of a change of bondholders. This is actually in contravention of the Sectional Title Schemes Management Act, because it requires that an owner provide this information to the body corporate. It also requires that the body corporate correspond with the bondholders regarding a notice of a meeting, and then of course to obtain their consent in certain instances. For example, the extensions of sections of more than 10% deviation. So that's, in my opinion, a breach of the Sectional Title Schemes Management Act. This is quite a biggie, and I'm sorry, I'm terrible at sharing screens and things like that. I want to get this one. There we go. The next one is quite a biggie in my opinion, and it's quite a clear contravention of the prescribed conduct rules. It's where installations on common property must be maintained by the body corporate. So it speaks about outside security gates, burglars, bars, canopies, etc. situated on the common property is the responsibility of the unit owners. They're saying, no, you cannot say that. It's the maintenance and repair responsibility of the body corporate. Well, that's completely in contravention of the prescribed conduct rules that says the owner can actually install, and the consent of the trustees is deemed to have been obtained when it comes to security devices and devices to keep out pests, etc., etc. And as long as the owner complies with the specifications or standard or design set by the trustees, their consent is not needed, and that the owner is responsible for the maintenance and remedial work to that installation. So that would be a direct contravention of the prescribed conduct rules, in my opinion. And again, just to remind you, the Practice Directive starts off with saying that this Practice Directive does not intend to amend or to be different to the provisions of the Sectional Title Schemes Management Act. Another thing that's interesting, and Mike Addison of AdShow might be online this morning. He's the insurance expert. It speaks about geysers and insurance cover. So again, I don't quite understand the wording of the Practice Directive, but it says that you can't make mention of the fact that any damages occurring to fittings, windows, carpets are covered by the body corporate's insurance policy, subject to the payment of an initial excess. This is actually literally what the prescribed management rule says must be contained in the rules. So again, there's a bit of a contravention to the Act. Another one is quite an interesting one for us, and when it came out, Nicole and I feverishly went through all of our rules that we had done recently to delete it without even questioning it, and that was the towing of vehicles. We've simply been told that a vehicle will not be towed. So why? Why can't a vehicle be towed? I know in my experience as a managing agent years and years ago that it was exceptionally difficult to actually get a company out to tow a motor vehicle, and one would be very cautious to make sure the body corporate's not responsible for any damage. But why is towing not allowed? And if towing is not allowed, then surely wheel clamping shouldn't be allowed, but they haven't said anything about wheel clamping. And if towing and wheel clamping is not allowed, then the only thing left is a summary fine. A summary fine is not allowed. So what exactly shall we do other than just allow a free-for-all? So the next item, quite a biggie, is slaughtering, ritual slaughtering on the common property and within sections and exclusive use areas. Shirley Bailey, who is online this morning, very kindly wrote us an article a couple of weeks ago, which we've posted on our website. You're more than welcome to go take a look at that. And Shirley's going to chat to us this morning about ritual slaughtering. But Shirley, I'm going to ask you to do it at the end. So I'm not going to. All right. The next issue is exclusive use areas. Now, this is also, again, an interesting one. You know what? They're all interesting in my opinion. The Community Scheme Ombuds Service says that the exclusive use area rule must include a layout plan. That's quite correct, but that the layout plan has to be drafted by an architect or draftsman. This isn't actually a requirement, and the Surveyor General's manual actually specifically regulates how a layout plan needs to be prepared and who needs to prepare it. So again, this is a requirement of the CSOS that is not actually guided by the relevant legislation or practice manual. Another one is the holder of an exclusive use area may not let their exclusive use area without the consent here that an exclusive use area via registered or in terms of the rules is for the use and enjoyment of the owner of a section or their occupier, which means that an exclusive use area actually cannot be let out to anybody other than the occupier of the section, so the tenant of the section, if the owner is not resident in the section themselves or using the exclusive use area. So it cannot be let by any other member or occupier in the scheme, and it most certainly cannot be let by an outsider to the scheme. Maintenance and repair, the practice directive says that you cannot have a rule where an owner is responsible for the maintenance and repair of their exclusive use area. I disagree with that. You can have a management rule that delegates the function of the body corporate's remedial and maintenance work to the owner. And I see this very, very often in sectional title schemes. And then, of course, you wouldn't make the owner responsible to pay contributions if they're responsible to actually deal with their own maintenance and remedial work, except, of course, if there's additional amounts that are due and payable, for example, insurance or rates or anything along those lines. The next one is business activities. It looks like the CSOS is saying that running a business or working from home is a change of use. I don't agree with that. I don't believe that it's a change of use, provided, of course, that you haven't taken out all the living or residential facilities to have a couple of desks and have clients and staff coming and going. And I know that there's a debate in Nicole's Homeowners Association as to whether or not her neighbor has in fact turned their property into an office space. We don't know, still subject to debate. But as long as the working from home is not going to cause a nuisance or disturbance or unreasonably use the resources of the scheme, and then of course that the unit is still going to be used for residential purposes, we don't believe that it is a change of use. And that brings me to the argument of whether or not short-term letting is considered to be a change of use as well. We don't believe that it is. The next one is a DSTV dish or solar panel installation. They say that it needs to be done by a certified professional installer. I don't believe that the Community Scheme Ombuds Service can dictate who the installer is. If it is your DSTV dish, they can, of course, tell you you're not allowed to work on the common property dish or the central dish or the solar panels of the scheme, or, of course, interfere with or appoint a random contractor to work on it. That's something a body corporate has to deal with. The development period, this is one that I'm not quite sure why it's a requirement. I've never ever seen it or had it in the rules. The CSOS says that when there is a right of extension of a sectional title scheme, the development period, in other words, the right of extension period, needs to be contained in the rules. This is actually in the certificate, the conveyance certificate, in terms of section 11.3b of the Sectional Titles Act. So it doesn't need to be in the rules. I'm not quite sure of the purpose for it being in the rules. The next one is a bit of an emotional one, I suppose, and it's so difficult for me when I consult with clients that don't want to allow pets in their scheme, because I'm a dog mom. I've got way too many dogs for my own good. But the question is always brought up as to whether or not an emotional support animal or emotional support dog, rather, is allowed in a sectional title scheme. So the prescribed conduct rules specifically speak about a guide, hearing, or assistance dog in the event of a disability in that regard, having deemed to have been obtained the consent of the trustees. Of course, the doggy still needs to be treated like any other animal and needs to make sure that conditions are adhered to in the scheme. But we very often get requests from owners to say that I've got a miniature Maltese poodle that has been with me for the last 13 years, and they are my best friend, and my psychologist says that I have to have them, etc., etc. Is that considered to be a guide, hearing, or assistance dog? In our opinion, no, it's not. Nicole and I recently dealt with a request for an emotional support cat. I love that one. So the rule only speaks about a dog. So unfortunately, we don't look at the kitty cat. But the CSOS has opened up this discussion for an emotional support animal. So I'd be very interested to see how this pans out. Records of the body corporates. It specifically says that the annual financial statements must be made available in electronic formats when an owner wants to request a copy of it. This is in contravention of the prescribed management rule that says it must be made available for inspection and copies. There's no legal requirement on any record of the body corporate having to be made available via email. Of course, in today's day and age, unless you're going to have to spend hours and hours of collating that information to provide via email, people aren't relatively available to come and undertake inspections. But that's what the Act says, inspection and copies. And of course, copies at a fee. Fiduciary duty of the trustees. This is also quite a big one. Where is it? There we go. Oops, now I'm going past it. Okay, we'll find it now. The Community Scheme Ombuds Service is saying that once a trustee has resigned or is no longer a trustee, hasn't been voted in, their fiduciary duty to the body corporate continues. In other words, they still have to be part of decision-making when it comes to disputes. They have to be part of assisting and answering to disputes, assisting the current trustees. I don't believe that's the case. And from a fidelity insurance perspective, I don't believe that ex-trustees are covered anymore in terms of the body corporate insurance policy, the same way ex-managing agents wouldn't be. And I'm not quite sure how ex-trustees can be part of decision-making when they don't have decision-making powers. I've got personal experience where an application was made after I had resigned as a trustee, and the owner had actually cited me as a party to the application, and after I engaged with the CSOS, I was excused from the matter simply because I was no longer a trustee. So it would be interesting to see the trustees, rather the CSOS's comments on this particular requirement. And the last one that I'd like to speak about before I hand over to Shirley to speak about ritual slaughtering for the next 10 minutes or so is levies. So the Community Scheme Ombuds Service says that if you are in arrears with your levies, you cannot be excluded from a vote. And again, the Community Scheme, rather the Sectional Title Schemes Management Act actually speaks about in the event of a judgment or an order being made against you, you can't vote on an ordinary resolution. So that CSOS Practice Directive would be in contravention of the Sectional Title Schemes Management Act. As you can see, there's quite a lot of different undesirable rules, 28 actually. Many of them are very good ones. They make sense, they're logical, they're needing to be abided by in terms of the constitution of the country, for example, the disconnection of electricity and water or services. But some of them, either their wording simply doesn't make sense and requires clarification, and a couple of them are in direct contravention of the Sectional Title Schemes Management Act and the prescribed management rules and conduct rules. So in my opinion, there's most certainly some work that is required by the Community Scheme Ombuds Service in updating this practice directive, or at least clarifying the practice directive, which I would like your input on as stakeholders and role players in the industry. And we'll be putting that all in formal correspondence, like I said, to the CSOS, and then make it available to you as well as their response. So exciting times ahead. Shirley, would you like to have a chat to us this morning about ritual slaughtering? Over to you.
I'd love to. Thank you. Am I being heard now and seen?
Yes.
Oh,
yes.
great. Okay. I was so incensed when I started looking through rules that there's a blanket rule that has been put in so many sets of conduct rules about ritual slaughtering may not take place on the common property. It has to take part in a section. And having come from a long line of people in my family that you always listen to your mother and you always do things at school by the law, I'm quite a law-abiding citizen. So that's what I'd like to do in life. But when you start to get older, you start to realize there has to be reason for rules and they have to be practical. And I'm always about practical. Zerlinda knows that I want the legislation to be practical. I want it to apply to everyday people so that they don't have to be lawyers to understand it. And so I was very happy when CSOS started getting involved in vetting the rules. And because up for such a long time, they just went into a bottomless pit somewhere in the deeds office. So I thought that this dictatorial attitude that so many people have when they write the rules would actually disappear. But it has happened to a large degree. And as CSOS has brought out, they've got very involved now. Maybe too much after what I've heard from Zerlinda. I never even thought about half of those things not being right. But the ritual slaughter is one that intrigues me because it's not that prescriptive. It is a hot potato in the terms of everybody living in sectional title. But they are not that prescriptive in what they're saying in the directive recently. And but yet the lawyers are taking it, and I say the lawyers because here we don't have lawyers, we only have consultants. I found out about Zerlinda. She doesn't like calling herself a lawyer, I don't think, anymore. It's just useful background. But so many sets of rules have got that slaughtering of animals for religious and cultural purposes shall only be permitted within the confines of a section and not under any circumstances on common property. And for somebody who, like me, who actually translates the law into reality, I don't think this works for me. You have to consider the practical aspects. And it's not even what CSOS is saying. So CSOS has laid down that you can't ban it. That I understand. And they say you should get these certificates. They don't even say you have to. Yet the imposition in the rules is so harsh that it's not working. So you have to, I think, consider each practical case and the circumstances and the layout of the building or the grounds, because there are alternatives. And certainly one of the requirements of the CSOS regulations is the trustees need to apply their minds. And I don't think they always do. So what I'm saying, reasonable arrangements should be made. It is so easy to go and look in a grounds, and maybe that's the lawyers don't get the plans of the place. I don't know. But so what I'm saying is that definitely ritual slaughter has to be allowed because otherwise it's against the Constitution. But don't make it so that it has to be a dissection. Because what happens then? You're going to have to get, if it's a cow, for example, and the section's on the 7th floor, you're going to run it up the stairs and it's going to poo all the way and make a mess. Or you're going to put it in the lift and the lift will be overloaded by the time the minders get in and the cow gets in, and the lift's going to break. And the noise and the mess is going to disturb everybody anyway. So by the time this poor cow, and it may be a goat, that would be much easier, or a chicken. But if it's a cow and it gets to the front door and then it sticks in the front door because the front door is not wide enough for the cow to get through. Now, isn't this going to make so much more mess and so much more disturbance? And then you get the cow inside by hook or by crook, and then you have to slaughter it. Now, where is this blood going to go? I mean, it could leak down through the floor into the roof of the place downstairs because there's no such thing as drainage in flats for blood or water. I mean, if you have a washing machine that actually floods the place, you have a drama. So blood would be even worse. So let's go to other aspects that you could apply your mind to. If you've got garden, why don't you rope off a section or designate a section at wherever it can be, away from the primary areas, so there's not so much possibility people can see what's going on. Ask all the neighbors, get their permission. Then you put ablution blocks there, or ablution portaloo, or whatever you call it. Restrict the time that it can happen. Don't allow alcohol. Only so many people can attend. Wouldn't that make more sense? It can be over in 2 hours, and there's not all this damage down the passage and the disturbance. Second thing can be, if you live in a large high-rise building, maybe you could have a corner of the car park where it could take place, where it's very unobtrusive. And one of the manager agents that I approached about this, she was the one that came up with a lot of practical suggestions. And she said in 2 instances with body corporates that had just done that, no problems. And in fact, interestingly enough, they did not even put into their rules that ritual slaughter was banned. They actually just left it out. So each occasion, the person or that wanted to have the ritual slaughter approached them, and they said, okay, this is what we think is best. So there's a lot to be thought about, not just this blanket, you can only have it in a section. And then just to end, I want to say, I went back to the people that practice the ritual slaughter the most. And I asked my housekeeper what she did, because she lives in Guguleto. And I said, what happens there? She said, it hardly ever happens at all. She said, the people who practice it always go home to their home areas, like the Eastern Cape. And she said, if they're Cape Town dwellers and they don't have a home to go to in the Eastern Cape, they go and find somebody's neighbor or somebody who has got a garden that they can do it in properly. There's no on the street corners and in blocks of flats. She says it doesn't actually happen. And finally, her last comment was, anyway, it should be in the open space, because part of the ritual slaughter is that you make your own homemade beer, and you have to do that in the open. So what I'm saying, to apply your minds to all the rules, but particularly to ritual slaughter, which is such a hot potato at this current time.
Unmute myself. There we go. Shirley, thank you so much for sharing that practical view. I really enjoyed reading your article before we posted it, so I would really recommend those that are online this morning to go and have a look at it. It's on our website under our blog post, and if you've got any comments on it, you're more than welcome to share it. I know that the topic of ritual slaughtering is obviously a hot topic, as is anything that deals with our constitutional rights. And many people have different views on it. And of course, we're also entitled to all of our opinions as well. So, freedom of speech and freedom of expression and all those fun things. So, the rules have to cater for all of these different ideologies. So I'd like to now open the floor to some questions and answers. I've got a couple on the chat function that we can have a look at. And then, of course, if you do have any questions that you'd like to raise verbally, you're more than welcome to do so. You can stick your hand up or unmute yourself. Is there anybody that online while we're busy? You can pop your hand up, or you can unmute yourself and ask the question, or make a comment. It doesn't have to be a question, it can just be a comment. All right.
Can I say something?
Yes, of course.
Zerlinda, thank you. I just think what you've highlighted is so amazing. I mean, this is why, thank goodness, we've got people like you who also think in the real world. Because I deal with this every day, all these issues, and but I don't see it like that. So thank you very much for highlighting, and thank you for whatever input goes to CSOS. If they don't listen to you, they're really not being good people.
Well, it's listening to us. I know that somebody that is quite vocal on the sectional title forum on Facebook, Nigel Capito, has already sent me a couple of his comments.
Yeah.
So, of course, anybody else is welcome to do so. I'm going to run it through a couple of the questions that were on the chat function. So if you do have a question, you're more than welcome to stick your hand up and we can just unmute you and we can chat about that or your comments. The first one was as a result of my comments about the consolidated format. So when you do table amended management rules or conduct rules for community scheme ombud service, you can't simply send that one rule that you've amended. You have to send your conduct or management rules in consolidated format. And what that means is that you basically have to take your entire set of rules, ensure that the format complies with the Sectional Title Schemes Management Act, with an index, for example, with a take note provision, with no references to Sectional Titles Act, but rather Sectional Title Schemes Management Act. And then, of course, it has to incorporate every single amendment that you've done since the establishment of the body corporate. So you can't go and submit 110 different pages with 110 different sets of minutes and resolutions. It all needs to be in one document, bearing in mind that you can't change the content of the rules that haven't been proposed to the members as part of the annual general meeting or special general meeting. So that's what the consolidated format means. We have a next comment: if we should treat everyone the same, how does this limitation on fines restrict? It's like I said, it's very unclear, the fining provision. If you're going to treat everyone the same, in my opinion, it means that you're not going to charge somebody with a larger apartment the same as somebody, rather more than somebody with a smaller apartment for exactly the same offense.
We've got another one, a comment rather. We have a prescribed management rule about legal costs from when the scheme was registered 20 years ago. Registered the deeds office. Is this still valid or not? Yes, it would be valid unless it contravenes the prescribed management rules under the Sectional Title Schemes Management Act. There is another comment, notifications to banks. Notifications to banks will also impact the insurance and any notice of interest in the policy. I'm not too sure, Sharon, if you're wanting to elaborate on that point. I'm not too sure if I'm following you. The moment we've got Derek, he's got his hand up. Derek, please, I'm asking you to unmute yourself. You're more than welcome to ask a question, make a comment.
Hi, everybody.
Hi there.
Hi, Zerlinda. Just a couple of things I thought I would mention. I actually wanted to reach out to you after the last session with Jolene. Been very busy with Popey and haven't got to it, but I would like to anyway have that discussion. So just a couple of things regarding the abandonment of vehicles. That's always a tough topic. There's it's regarding towing, and that's something that needs to be dealt with, because quite often certain, like in estates, the reason why I mention this is because I'm currently dealing with one now where you have sort of some sectional title complexes within a large golfing estate, for example, and people feel that they can just go and park their vehicle in another complex and leave it there. Nobody knows who it belongs to. And now, you know, what do you do in a case like that? You get a court order. Who does it get served on? Where does it go to? Okay. The other one important, I feel, especially to mention, business use. So I'm not sure. I've been writing this in rules for some time now, but in terms of town planning, and it may change by area to area, but anything that's less than 25% of the main use will be seen as incidental. So you mentioned the point about somebody converting it into offices. Yes, well, that is definitely not residential, and then that's definitely changing the purpose. But if you use a room, you know, and you're only using 25%, then that won't be seen as business use. Okay. And then a hot topic is regarding pets. So there was a recent case, or some case, that certain attorneys put out a comment regarding a ruling that was made by CSOS. And I think this is important for everybody to know. And the reason that CSOS was brought into play on this one was because the rules of the complex said no cats. And somebody, one of the owners raised the question and said, but why? Doesn't apply to all, and the same rule should apply to all pets, whether it's a cat and a dog. And to cut this, to go to directly to the point, CSOS overruled the body corporate and said they now are permitted to have the cat. So now the question comes in. This is where I have the concern with CSOS, is CSOS they apply the undesirable rules, what they term as undesirable, across the board. When they review rules, they don't take into background or understand why a rule was put into place and why it was voted via special resolution by the members. Okay. In this case, they had a problem with cats, and the owners decided no cats because of that. In other words, damaging furniture, going through windows, being an inconvenience and a nuisance. So they overrode it. But then if they're going to do that, then the same principle should apply to what applies to dogs. Now, dog is not allowed on the common property if it's not on a leash. So then if it's going to be treated fairly, then the cat should fall into the same ruling as the dogs. Okay? So my question comes in, at what stage is CSOS overruling their mandate in terms of over-regulating, let me put it that way, the schemes? And I think that's something that's very important in terms of they are rejecting and not approving rules when there's an absolute valid reason, but now they're overriding what the members via special resolution have decided that that's what they want in the complex.
Derek,
Okay.
you've raised some very valuable points. I'm going to ask you to please send me an email with them. And of course, we're going to share them with our attendees today, as well as the Community Scheme Ombud Service. I just want to deal with a couple of more comments on the chat function, and then, of course, questions that might come through. I'm having a look over here. Here's a comment. If a complex has roof problems, windows, outside need attention, the body corporate says it's the owner's problem. What do you do in this situation? So, you know, it's not really related to the practice directive, but there it's a 50-50 responsibility. The median line applies, so you need to keep that in the back of your mind. Any suggestion on how to get the required number of members to attend the meeting where the management rules are to be amended? The unwillingness of owners to attend the meeting is absolutely hindering. I've actually consulted yesterday with a body corporate where we've had to look at quite a creative way of dealing with the issue to avoid unanimous resolution, simply because of the quorum requirements. Oh, sorry. So that's very difficult. If anybody is online that has been able to successfully pass unanimous resolutions, getting a quorum, your input will definitely be very, very welcome. Another question is, can I ask about trees in exclusive use areas? Can it be in the rules that it's responsibility of the owner if they planted the tree? Most certainly. What about overcrowding? What is regarded as overcrowding? I know the municipal bylaws apply there. Derek is very, very fay with all of the municipal bylaws, and he'd be able to assist with that query. Derek, if you're wanting to pop your answer into the chat function, that would be great. Generally, anyone may do anything on common property that doesn't obstruct or disturb others. So the concept of not including slaughtering in the rules, but finding a solution when requested makes sense, most certainly. So there's quite a few comments on the ritual slaughtering issue. I do suggest you go and have a look at Shirley's article on that point. Ex-trustees should assist new trustees in matters still under dispute for input purposes, but not others. The reason is that trustees can just resign and there's no accountability. Easy way out, most certainly. I don't think that they can be forced, however, to do that. Those are some of the comments that are on the chat function. Is there anybody else that would like to raise their comment or query live with us this morning? You're welcome to unmute yourselves.
Linda?
Sorry. Ruth, yes?
I just have a one about the cat story. Have you ever actually read the bylaws?
I have, yeah.
Actually don't allow more than 4 cats over the age of 6 months to be kept on any premises. 6 cats or allow more than 6 to be kept on an agricultural property. It doesn't, like the dog bylaw breaks it down to dwelling units and all the rest of it. So you get your numbers for the flats. Like you allow 2 dogs or more kept in a dwelling unit. Not 2 dogs or allow more than 2 dogs. So you're not allowed to keep more than that in a dwelling unit. And the dwelling unit is under your at the top. But premises means any building, tent, or other structure. So in other words, any body corporate, technically, according to the city council bylaws for animals, cannot have more than 4 cats on those premises. So, and I've never seen anything unpack that.
Very interesting. You're talking about the Cape Town bylaws, eh?
Yeah. The City of Cape Town Animal Bylaw 2010.
Very true. We've got a comment here from Vonnie. I submitted rules to the CSOS for a POA and had to remove the word loitering or change the word. I do not understand why. So under the practice directive, again, for sectional title schemes, there is a reference to, loitering, specifically in the context of domestic workers, contractors, employees of the body corporates, and they link it to, the anti-discriminatory issues under the Constitution. So you mentioned, Vonnie, that you submitted rules for a POA. Just as a reminder, if you have a homeowners association, the Constitution or the Memorandum of Incorporation or the rules under that governance documentation is not subject to review and approval by the Community Scheme Ombuds Service. And they actually do mention that in their practice directive, and Jolene does mention that in the slides of her last presentation as well. Somebody commented, what's a POA? A POA is a property owners association, homeowners association, master homeowners association, residential community, all the weird names that it comes under, but basically it's either non-profit company or an association in terms of the common law. Ruth, thank you very much for that. The City of Cape Town Animal Bylaw 2010. Is there any other comments or questions? There was another.
Zerlinda, yes, I've got a question for you.
Yes.
My name is Sandra. I just wanted to ask you a quick question. I just had a meeting with one of my managing agents, and they say that trustees can't be reimbursed because it goes against the law of papaya. Can you elaborate on that?
No, not something that I've heard before. Trustee, in terms of the Sectional Title Schemes Management Act, can be reimbursed for expenses that they've incurred. So, for example, printing costs of petrol or anything along those lines. It's not in contravention of anything, no. Any other questions or comments before we go?
Sorry, just to clarify, for their time, to be reimbursed for their time, they say
that's different. That's different.
It's in contravention.
So a trustee that is a non-member can be compensated for their time, provided that it is included in the budget of the body corporate and passed by ordinary resolution. And a trustee that is a member needs a special resolution of the members. This is the Sectional Title Schemes Management Act. Ladies and gentlemen, just a reminder that if you would like to make any comments or questions on this practice directive, please do pop me an email or Nicole an email. Have a look at our website for Shirley's article, as well as for a recording of today's session and the one by Jolene of the 13th of May. We thank you so much for your time this morning. If you would like to hang back for a couple of minutes afterwards, I'll keep myself online for a few minutes, and then the team and I have to go on to a meeting. But just as a last reminder, if you do have any comments or queries in regard to your scheme's rules, management or conduct rules, please do contact us, and we can assist you in the review and amendment process of that. You can contact us at info@tvdmconsultants.com, Zerlinda@tvdmconsultants.com, or Nicole@tvdmconsultants.com, and as from Monday, Lemese@tvdmconsultants.com. Ladies and gents, thank you so much for your time. Have a lovely weekend, and I hope to see you in our next webinar that will be held next month.